Back on record, the time is 10:14 a.m.
Okay. So I want to ask you about the rental agreement, which I'll attach as Plaintiff's Exhibit 2. This is actually the renewal rental agreement, and then there's the original rental agreement. Get that to you. Is that the rental agreement that you had with Tyler Rhodes and his roommate, Adriana Pemberton?
Yes, this appears to be the renewal rental agreement.
At the time that the fire occurred, did Mr. Rhodes have an active rental agreement with the property owner, 2018-3 IH Borrower LP?
Yes.
Okay, and you would agree that at the top of the rental agreement it says Invitation Homes?
Yes.
I want to ask you a question about insurance. Did at the time that the fire occurred, did Invitation Homes require its residents to have a renter's insurance policy?
We require, as the brand, Invitation Homes requires liability coverage, and a resident, they're tasked with making sure they provide documentation, or that would be forced placed at a later date. I believe it's within the first 2 weeks of their move-in. But any additional coverage, contents, any additional coverage they would like, we require or suggest or encourage them to do their own research to determine the coverage most appropriate for them.
Sure. Do you know if Mr. Rhodes and or Ms. Pemberton had a renter's policy at the time of the fire?
I don't know if they had a policy,
No.
a renter's insurance policy. No.
Okay. If Invitation Homes placed a policy, was it through a company that they owned, or would it be an outside company, or how was that done?
When you say Invitation Homes, who are you referring to?
Either Invitation Homes Incorporated, Invitation Homes Realty, and or THR Property Management, and or 2018-3 IH Borrower LP.
So the resident, like the policy that they would be forced placed with or that they would sign up for, they can choose their own provider, and then if they don't select their own provider and provide that documentation, we would force place, and it would be through a third party. The company currently, I believe, is Get Covered, and we've used Assurant and different providers over the course of time.
Do you know who it would have been in 2022 or 2023?
I believe it was Assurant at the time. I'm not 100% certain though.
And that's ASSURANT?
That's correct. I believe that's the case, but we would probably have to confirm that.
If you would turn to page, I think it's 27, the signature page. There might be actually, I guess there's several signature pages. 21 might be.
You still looking at the same lease agreement?
Oh, maybe whatever the signature page is. Might be 20 then.
20?
Yeah. And you referenced earlier a Charles Young. Is he the one that signed it?
That's correct. So, yeah.
Invitation Homes Incorporated, where are they located? Are they in Texas?
Invitation Homes, Inc., the publicly traded REIT, those details of the address are all disclosed online. I believe the address listed is the corporate office in Dallas, Texas.
Okay. Can I do something real quick? So it says that, like, in terms of the insurance coverage, it says interested party notifications or any notice of lapse in coverage or notice of cancellation of coverage must be forwarded by U.S. mail to Invitation Homes, and it gives an address in Texas. Do you know if that's Invitation Homes Realty or if that's Invitation Homes Incorporated, or which Invitation Homes that would be? And just for reference, that's on, what page is that?
Page 35.
Okay, thank you.
Yeah, this is Invitation Homes, the brand, but once again, the property management company, THR Property Management, those are the associates behind the scenes that are, helping to, facilitate that we have the information we need. And so this is a PO box where those insurance documents are delivered to our third-party provider so that they have the information in our financial system of record, Yardi.
What was that?
Yardi, Y-A-R-D-I. That's our financial system of record and software that we use. And they can also, there's an email option here where they can email that coverage in as well.
Okay, thank you. Take a look at it again.
Yeah.
What is your email address?
My email address, Invitation Homes, jgossett@invitationhomes.com.
Then on the front page, the first page, 1 of 47, it says copyright 2021 Invitation Homes, all rights reserved on the bottom of the page. In terms of this documents that's used, was this drafted by Invitation Homes and then given to Invitation Homes Realty LLC and our 2018, or THR Property Management?
Do you mean the publicly traded Invitation Homes, Inc.?
Well, I don't know, it just says Invitation Homes, so I'm just wondering.
Yeah, this at the bottom, 2021 Invitation Homes, as is the case with the top of the page, refers to the publicly traded REIT, the brand Invitation Homes, versus the management entity or the ownership entity.
What control, if any, does Invitation Homes Incorporated have in terms of the leasing agreement that's utilized by 2018-3 IH borrower?
We have a centralized team that helps to facilitate execution of lease agreements and, compliance of, versions of lease agreements that coordinate with our legal team to make any updates required.
And is that team through Invitation Homes Incorporated?
Once again, Invitation Homes, Inc. is the publicly traded REIT, and associates mostly report under the management entity, THR Property Management.
What control, if any, does Invitation Homes Incorporated have over the Tampa market for homes that are owned and or managed by Invitation Homes Realty LLC and our 2018-3 IH borrower and or THR Property Management?
Invitation Homes, Inc. is a publicly traded REIT. The management and compliance and oversight, just general operations, takes place through THR Property Management or Invitation Homes Realty.
Is there any control that's exercised directly by Invitation Homes Incorporated over the Jacksonville market for homes that are owned by 2018-3 IH borrower?
Check the form.
Any management oversight is conducted through THR Property Management.
Understood, but my question is a little broader than that.
Yeah.
My question is, does Invitation Homes Incorporated exercise any control over this market or in the state of Florida that you're aware of? Or do they not?
So on our website, Invitation Homes, Inc., communicates a board of directors, and this is all public information through our proxy on our website. And, there are certainly meetings that take place, through our board of directors where higher level, decisions are made, but any management of the actual properties at a market level, whether it be Tampa or Jacksonville or any of our 16 markets, takes place through THR Property Management.
Okay, so Invitation Homes Incorporated may have some broader policy or procedures control, but in terms of the operations, that would be managed locally.
Any of the policies and procedures that are enforced and executed at the market level, those are done within the property management entity. Invitation Homes, Inc. is the publicly traded REIT, and so any business through the REIT, once again, as a publicly traded company, that information is outlined on our website, any of those decisions that are made.
Understood. So I want to go over the smoke and carbon monoxide alarm policy. Do you have a copy of it? I may have not done a third copy of that. This
I
one.
just want to see it before you
Sure.
hand it to him.
And I'll attach this policy as
Right?
Plaintiff's Exhibit 3. Actually, I just found it. I do have a copy for you. Is this one of the documents that you reviewed in preparation for your deposition today?
Yes.
Okay, and what I've done is these were, I think, originally on separate pages, but to save space, I've put 2 pages on one. Is this the smoke and carbon monoxide alarm policy for THR Property Management and/or Invitation Homes Realty LLC?
Yes.
And then on the other page, there's a specific Florida section, which I'm assuming is also the part of that policy, right?
That's correct.
And there's, it says RTM department. Do you see that
What page?
on all the pages?
Yeah. Yeah.
Um,
Rehab turns and maintenance.
Okay, thank you. So I want to go through this. So in looking at this document, what is the purpose of having a smoke and carbon monoxide alarm policy?
To ensure consistency, with how we operate as it relates to smoke and carbon monoxide alarms, whether it's, rehab turns or maintenance of homes.
Okay. Now, I was curious because it says, under purpose, it says, specifically, this document provides Invitation Homes associates with guidelines related to the installation, testing, and replacement of smoke and carbon monoxide alarms. Did I read that portion correctly?
That's correct.
Okay. Now, in looking at this document, I see Invitation Homes, and then it says Invitation Homes Associates, but it doesn't say THR Property Management or Invitation Homes Realty. So is this a policy that's directly from Invitation Homes Incorporated?
This is a policy referring to Invitation Homes, the brand, and the associates reference would be associates of THR Property Management, which would be responsible for actually enforcing the policy.
Okay, was this policy, does this come from Invitation Homes, though?
This policy comes from THR Property Management because the associates, from a centralized perspective, that are, in many cases, developing these policies are under the umbrella of THR Property Management.
Well, the reason I ask is on the bottom it says 2022 Invitation Homes LP. Who is Invitation Homes LP?
Limited partnership.
Is that the main entity or someone else?
It's another entity, another one of our many entities.
Okay, who is that entity?
I mean, it's a subsidiary of, Invitation Homes, Inc. is Invitation Homes, LP.
Who drafted this policy?
This was drafted by THR Property Management team members. I mean, it says Invitation Homes, the brand. Invitation Homes LP is referenced at the bottom, probably a legal requirement. You see the, equal opportunity logo at the bottom as well.
Was this meant for like all properties within the Invitation Homes brand?
This was meant for all associates under THR Property Management, which are responsible for the management of Invitation Homes legal entities.
Okay. So it gives a background, and it states that smoke and carbon monoxide alarms are safety devices to alert the occupants in a home of the possible dangerous conditions related to smoke, fire, and carbon monoxide. Requirements for smoke and carbon monoxide alarms in residential properties are set at the state and in some cases municipal level. Did I read that portion correctly?
That's correct.
And then, consistent with what you said earlier, it says, it talks about that the policy was to create consistency in the brand, right? For all, it says for all Invitation Homes properties.
That's correct. Consistently introduces minimal guidelines for all Invitation Homes properties. That's what it reads.
Okay. And then under policy, it says Invitation Homes market teams. What does that mean, market teams?
Market teams, I reference in my opening statement or questions, I've got a team of about 130 associates just under the Tampa umbrella. That would be considered our market team, is those 130 associates. So any THR property management or Invitation Homes Realty associates that are under the brand in the market, those are the market teams.
It says Invitation Homes market team shall follow the guidance provided in this document regarding the placement, testing, and maintenance of smoke and carbon monoxide alarms. In some cases, the standards outlined below exceed local requirements. And then it says, however, in situations where local requirements exceed Invitation Home standards, market teams must follow the more stringent requirements. Did I read that correctly?
That's correct.
Was this the policy in place at the time of the fire?
This policy was not in place. This policy was in place April 2022, the incident December 16th, 2023. This policy was in place. It was not in place at the initial move-in of Mr. Rhodes and Ms. Pemberton.
Okay. Why don't you tell me what the policy is as it applies to, let's deal with smoke detectors first, or smoke alarms. What was the policy for Invitation Homes Realty LLC and or THR Property Management LP?
General requirements: smoke and carbon monoxide alarms must be tested during the rehab and turn budgeting, final inspection processes, and during ProCare post-move-in and maintenance visits. If an alarm does not function as intended, it must be replaced with the following guidelines. A hardwired alarm is replaced. It must be replaced with another hardwired alarm. All newly installed replacement alarms, hardwired or solely powered by a battery, must feature a non-replaceable, non-removable battery that can power the alarm for a 10-year lifespan. Batteries are replaced in any existing alarm. 10-year lithium-ion batteries must be used for the replacement. Repair or replacement of any alarms must occur within 4 days of receiving notice of defect from the resident. Homes without hardwired smoke alarms must be upgraded to include them during significant remodel activity when required by local and permitting requirements. If upgraded, carbon monoxide alarms must be upgraded to be hardwired and interconnected at the same. Those are general requirements. There's also rehab requirements, which is the next section. And so,
Yeah, tell me about that.
All right, so following the completion of a rehab, smoke and carbon monoxide alarms must meet the following standards. All alarms must be new. All alarms must be interconnected. All alarms must receive their primary power from the building. Wiring must feature a non-replaceable, non-removable battery. that can power the smoke alarm for a 10-year lifespan. For carbon monoxide alarms, these requirements are typically met by installing combination and smoke and carbon monoxide alarms in place of standard smoke alarms as needed to meet the carbon monoxide alarm local requirements.
As the corporate representative of Invitation Homes, is it your expectation that any workers that are implementing this policy do so with exactness?
We expect, as it's outlined in the policy, that associates are following the policy. It's why the policy is in place.
So I took the deposition of Mr. Staples, and he testified on page 30 and 31 that that he was aware that there is a 10-year expiration basically to smoke detectors. Were you aware that that smoke detectors are only good for 10 years?
Check the form, foundation.
Yes, I mean, our policy is in place for us to replace smoke detectors every 10 years. The reason we do that is because, you know, the lifespan of the smoke detector.
So Mr. Staples testified, again, this is page 30 of his deposition transcript. He says, "We would verify, all the smoke detectors were working properly within the right, correct date range prior to us turning over the leasing department to install." So he said that they would actually check the date to make sure that, it was within, the 10 years. And that's what they would do as part of their standard. Do you agree that that is the standard, or do you disagree with Mr. Staples?
Check the form, you can answer.
The standard, as stated in the policy, is to make sure, and it's actually in our ProCare policy on the occupied side of the house, is to make sure that we're consistently, checking smoke detectors, whether it's in the rehab and turn of a home, or whether it's on the occupied side of the home.
Okay. How would you know if it was within 10 years if you don't check the date?
Check the form, you can answer.
The date is on the smoke detector, and we actually, now write the dates of installation, since this policy was instituted on smoke detectors.
Sure, but would you expect an associate to actually unscrew the smoke detector, you turn,
They
right?
check,
And you
yes.
just check the date?
They check. They do check.
Okay. That's the expectation of Invitation Homes Realty and THR Property Management.
And that's part of the policy, is to, to ensure that, it's within the lifespan, check the date.
Sure. Now, let's say that the smoke detector was expired. Is it the policy of Invitation Homes, even though the smoke detector is expired, just to slap another battery in there because that's cheaper?
Check the form, you can answer.
The policy is if it's over 10 years, we replace the smoke detector. And it's differentiated here, with how we handle rehabs and turns versus maintenance.
Okay, so, well, if Mr. Staples testified that during turns and during rehabs, they check the dates, you disagree with that, though?
I don't disagree with that.
Oh, okay.
No.
Okay, and,
I was referring more to, occupied side of the house versus rehab and turn side of the house with our ProCare policy. More detail outlined in our ProCare policy, I think.
okay. And we'll get into like the ProCare visits in a little bit. Would it ever be acceptable if, to you, if a smoke detector needed to be replaced because it was outside of the 10 years, to disregard that policy and just install a new battery?
Check the form.
No, the policy is in place because we want to make sure that it's adhered to, and part of that policy is if it's 10 years or older, we check it, we replace it.
Okay. Now, is there any policy for Invitation Homes Well, let me ask it this way. Are you aware that some smoke alarms are incompatible with other smoke alarms?
Am I aware? I'm not an expert when it comes to smoke alarms. I just, know the general standards and, codes and what's in the policy. So,
Let's say that a turn was being done, and an associate noticed that the smoke detector was out of date and needed to be replaced. But you could also see that the other smoke detectors look very similar. Would you expect them to replace all smoke detectors that were out of date?
Check the form, you can answer.
I would imagine if they notice it's the same model and that one is out of date, I would expect they check the smoke detectors and, as part of the policy, replace anything that's out of date.
Okay. Now, if let's say that there was just one smoke detector that had a known malfunction, and that an associate installed or wanted to install a new 10-year lithium closed system, which I believe is the new standard in Florida and also in your policy, that they're tamper resistant. They have like an internal battery, a 10-year lithium battery, so you don't change out the battery.
Right.
Would it be your expectation that the associate read the installation guidance to make sure that the 10-year lithium that's being installed is compatible with the other system that's present?
I would expect, as is the case outlined in the policy and other, occupied visits, that they're testing the smoke detectors and replacing any equipment that needs to be replaced, and, following the guidelines. And we do training on smoke detectors and safety, and, we have monthly, actually bi-weekly or monthly alignment meetings with our superintendents where we review this type of detail on a consistent basis. And so my expectation would be that they're testing in the turn, and if equipment needs to be replaced based on the policy, they're replacing
it. Would it be potentially dangerous to disregard that policy
Check the
and
form.
not replace smoke detectors that are expired?
I think it could be potentially dangerous to disregard any policy, any policy especially that creates consistency and safeguards, for our associates and for residents.
Thank you. Including your policy for smoke detectors.
Can you repeat the question?
Sure. Is it potentially dangerous to disregard your smoke detector and carbon monoxide detector policy?
It's potentially dangerous to disregard any policy, including this one.
Okay, thank you. Okay, let's talk about carbon monoxide detectors. Now, the home that was involved in this fire, you would agree with me, so just for reference, the 3828 Trenton Lane property, did that property have an attached garage?
Yes, I believe so.
Okay. And if you turn to the Florida page, if a property has an attached garage, what is the requirement as it pertains to a carbon monoxide detector?
That's outlined here. So rehabs and new builds, smoke alarm must be installed in the following areas: sleeping room, outside of each separate sleeping area, and in the immediate vicinity of bedrooms, each additional story of the home, including basements and cellars, but not including crawl spaces and uninhabitable attics. On floors of bedrooms, smoke alarms should be installed in or near living areas such as dens, living rooms, or family rooms. All smoke detectors solely powered by a battery are required to feature a non-replaceable, non-removable battery that is capable of powering the smoke alarm for a 10-year lifespan. I think the detached garage detail, as you go down to carbon monoxide detectors, carbon monoxide alarms must be installed in each home that has a gas burning heater or appliance, fireplace, or attached garage.
Okay. And since we know that 3828 Trenton Lane, Northport, Florida, had an attached garage, would it be required that, according to your own policy, that there be a carbon monoxide detector?
According to number 1 here, for rehabs in new builds, carbon monoxide alarms must be installed in each home that has a gas burning heater or appliance, fireplace, or an attached garage. Keep in mind this policy was not in place at the time of move-in, and so you know, being that it was instituted in April 2022, it would not have been addressed in this scenario through a rehab and a turn. We would have potentially identified that as part of our ProCare maintenance visits and acted appropriately in that capacity.
Okay, so during a ProCare visit, if it was determined that there was not a carbon monoxide detector, what would have been the policy? Would it have been not to provide one or to provide one?
As part of the ProCare policy, we would test the existing smoke detectors and replace under the policy, but you know, anything under that's specified here would be done at the next rehab or turn, in this case, next turn.
Okay, so what if Florida law required that there was a strike that. What if Florida law required that a carbon monoxide detector be installed in a home with an attached garage? And so obviously you did a turn, I think in 2020 on this property.
Check the form, foundation.
So we can look
You're
at
saying
the,
there is a law?
well, what I'm really wanting to know is what the policy was when this property was turned. So let me ask you this, when was the property turned?
This, it was turned, I believe, 4 times post-acquisition in 2013, I believe 2015, 2018, 2020, and again in 2021. Prior to Mr. Rhodes' occupancy, it would have been turned in 2021, I believe, July 2021.
Yeah, so he took possession, well, the lease term starts November 19th, 2021. There, I can attach.
Yeah, so it was probably November 2021 was when it was last turned prior to Mr. Rhodes' occupancy.
Yeah.
It should be documented on the scope.
Yeah, and we'll take a look at that. But so what I want to know is, whenever the turn was done prior to Mr. Rhodes' occupancy, if Florida law required that there was a carbon monoxide detector because there was an attached garage, what would have been the policy of Invitation Homes? Would it have been to provide a carbon monoxide detector or not?
Check the form and foundation. You're suggesting that there is a law?
I'm
Or
just
you're
asking
giving a
if
hypothetical
there is
that
a law.
maybe there's a law?
If there is a law.
You can answer if you know.
I'm not a legal expert, and so I don't know all the laws, but I know that we would enforce the policy and stick to the policy when it was instituted, and regardless of policy, our team, would go and test and, make any replacements or repairs to equipment as needed.
Yeah, I'm just asking about the carbon monoxide detector. So we have the policy from 2022, right? We reviewed that. We've attached it as Plaintiff's Exhibit 3. I don't have a policy that has been provided to me about smoke alarms and carbon monoxide detectors prior to 2022. So you're the corporate representative, so at the time that Mr. Rhodes signed his lease agreement, which would have been in November of 2021, before that happened, before he signed that lease, what would have been the policy of Invitation Homes Realty and/or THR Property Management as it pertains to a carbon monoxide detector in a home with an attached garage?
We established the policy, was formalized in April 2022. Prior to that, our policy would have been to, test, and I wouldn't say policy, general guidelines and framework for our superintendents is, to make sure we're testing the equipment, any equipment, and, subcontracting through a GC, and they test all the mechanical stuff. And so specifically, I don't know, like I said, I'm not a legal expert, requirements, but we would most definitely do our best to follow any requirements that we're aware of, and that is outlined in our policies and procedures.
Okay, so before this policy came out in 2022, tell me, what was the policy for Invitation Homes Realty and/or THR Property Management as it pertains to whether a carbon monoxide detector would be provided in a residential home?
There was no formalized policy.
Okay.
The policy was instituted in April 2022.
Was there an informal policy?
I would say that there was an informal process and procedure, which is what I described, in making sure that we, through the scope of a home and coordinating with our GCs, identify anything that needs to be repaired or replaced in the home.
Was there a carbon monoxide detector at 3828 Trenton Lane?
I don't know.
If there was a Florida law that required a carbon, and I'm not an expert either, I'm just asking if there was a law that required a carbon monoxide detector in Florida, would it have been the policy of Invitation Homes to comply with Florida law as it pertains to carbon monoxide detectors?
Check the form foundation, you can answer.
I think our standard as it relates to any laws is, we want to do the best we can to be stewards of those laws and, operate within what's required. And so in this case, this wasn't formalized until April 2022. And so, we, coach and train and encourage our teams through regular meetings and alignment activities, to do what we determine is best based on how we scope a home, how we identify clean, safe, functional components. And so, yeah.
Do you know why a carbon monoxide detector is now required under the policy that we've talked about and attached as Plaintiff's Exhibit 3 in residential homes that have an attached garage?
Why?
Yes, sir.
I don't know specifically why.
What about in homes that had gas appliances? Do you know why a carbon monoxide detector would be required?
Once again, I'm not an expert. I can, draw conclusions on the why, but don't want to speculate. I mean, if you have a more specific question, I'm happy to answer.
Did the residents at 3828 Trenton Lane have any gas lines? And by gas, I would include propane, so gas or propane lines.
To my knowledge, there was no gas in the home. It was electric.
Now, in terms of the lease agreement, the original lease agreement, not the renewal. I'll attach. I'll attach that agreement as plaintiff's exhibit 4. Is this the original lease agreement that was signed by Tyler Rhodes and Ms. Pemberton?
Yes, this appears to be the original lease agreement.
I'm sorry, you're looking at the original lease agreement?
Yes.
Miss Pemberton, is that Rose and Pemberton, because she's not on here?
Yes, Pemberton is the resident.
No, I just need the spelling of the
Oh,
last name.
yeah, Pemberton,
Perfect, thank you.
Pemberton.
That's all I needed.
Yeah.
Okay, I want to show you another document that I received as part of discovery. This was a RTM Department April 2021 update. It looks like it's a let me attach this real quick. I'll attach this as plaintiff's exhibit 5. But this talks about pro-care visits, and we talked a little bit about it, and this looks like an update to the policy. This would have been a few months after, or actually, it would have been this would have been before Mr. Rhodes moved in. Have you ever seen this document before?
I have.
What is this?
This is the ProCare post-move-in and ProCare maintenance visit process.
Can you tell me about the ProCare process?
I can, and I think I'll reference under the background section, paragraph 2. It probably explains most succinctly. The ProCare life cycle begins with a resident orientation, which is conducted just prior to move-in. This is followed by post-maintenance visit, approximately 45 days after move-in, as well as recurring maintenance visits every 6 months until the resident moves out. However, just prior to move-out, the resident receives a pre-move-out visit, also known as a PMOV.
Sorry, what was that?
Pre-move-out visit, PMOV.
Yeah.
So generally, the ProCare program is in place to make sure that our internal invitation homes, THR property management associates, maintenance techs are, doing routine inspections as they're in homes, and that's the time frame. We try to get to those 45 days, 6 months, and every 6 months after that.
Okay. And in terms of those ProCare visits, was it required to check the smoke detectors?
It is. It's outlined in the ProCare visit checklist. It's also outlined that, this is reviewed with residents at the move-in orientation.
Okay, and they would be also required to check carbon monoxide detectors as well, right?
I have to refer to the policy, whether it refers to it as smoke detectors or smoke and carbon monoxide detectors. smoke and carbon monoxide detectors, page 3 in the safety check table. Safety check requires the associate to enter each room in the home, including the non-living areas, to identify and report the property management team areas where the resident behavior is creating a potential safety hazard.
Okay, now when they check the smoke alarm for the ProCare visit, would they also just check the date, make sure that the smoke alarm is not expired?
It's the smoke alarm, part of the ProCare is they're testing smoke alarms, and if they determine through testing that, you know, the equipment's defective, then they would replace those smoke alarms.
Okay, so is it the policy of Invitation Homes that you only check the date to see if it was expired, if it's a rehab or a turn?
I don't know if that's specifically, I don't know if checking the date is specifically outlined in here for maintenance visits. I will say that, you know, generally part of associates testing, you know, is making sure they're testing that the equipment is working. And so, you know, as part of that test, they're going room to room and testing the smoke detector equipment.
Okay, now in terms of like the lease requirement, the tenant has some responsibility as it pertains to the smoke detectors as well? Is that right?
That's correct.
Okay. Now, if they're supposed to test the smoke detector, I'd assume?
That's what the lease outlines, is that resident does have responsibility for testing and replacing batteries as needed.
Okay. And I saw that in the lease agreement about if a battery, I guess, is, well, if a battery needs to be replaced, usually the smoke alarm will beep, right? Tell you that the battery is.
Typically.
Yeah. But if they were checking the battery and a battery needed to be replaced, according to the lease agreement, that would be the responsibility of the tenant?
The tenant is in part responsible, according to the lease agreement, for testing the equipment and replacing batteries.
Okay. What about if, is the tenant responsible to replace the smoke detectors?
They are responsible for reporting if they conclude that the equipment is not functioning while they're testing. They're responsible for reporting defective equipment as part of the lease agreement.
Thank you. But it would not be the tenant's responsibility to go and wire in a smoke detector?
No, we would ask that they report that so that we can address any issue.
Okay. Now, what if a smoke detector was on a vaulted ceiling where, you know, typically a smoke detector, if it's an 8-foot ceiling, you can reach up and test it, right? Well, I can, I'm over 6 feet, but, or maybe even like a small step ladder, you can easily do that, and you'd agree with that?
So our policy is if your feet are above 10 feet, like, you know, we would contract that out. Like, we don't even want our in-house team, you know, with their feet above 10 feet.
Sure, I understand.
So,
But let's say that a smoke detector was on a vaulted ceiling, so it was, you know, you can even get on like a little step ladder. You know what I'm talking about? Like, you know, a couple step ladder. You would have to get a, you know, big ladder, climb up on the big ladder. Is that something that you would expect a tenant to do if it was on a vaulted ceiling? Let's say, you know, 12, 15 feet high, or would that be something that they could call ProCare, or I'm sorry, they could call an associate for them to do that?
Check the form.
if anyone's feet, like whether it's a resident or an Invitation Homes associate, is going to be above 10 feet based on the size or the height of the vaulted ceiling, we would thin that out, because we don't want, either a resident or our associate having to get on a large ladder where their feet are above 10 feet.
Okay. What if their feet had to go above 6 or 8 feet? Would you still expect the tenant to get?
The threshold is 10 feet, so,
Okay.
yeah.
So yes, you would expect the tenant to grab a ladder, climb up on the ladder, and then test the smoke alarm on a vaulted ceiling.
Check the form, you can answer.
That's correct.
Okay, there's another document, November 2019, RTM Department, ProCare Resident orientation process. And I'll attach this as Plaintiff's Exhibit 6. As part of the ProCare orientation, so it's my understanding that there's a ProCare visit shortly after the tenant takes occupancy, is that true?
Within 45 days, that's correct,
Thank you.
approximately.
So on page 10, oh, sorry, I'm going to ask you about page 10 of 13.
Looks like you have an extra piece of paper in there.
Oh, thanks. So I'm handing you Exhibit 6, and then if you turn to page 10, I'm going to ask you some questions about that. And my question is a simple one, is part of the ProCare visit after occupancy also explaining about the smoke detectors?
Ideally, explaining about the smoke detectors, and it is part of this policy, and I believe the update in 2021, is that a superintendent, either at or prior to move-in, ideally, 24 to 48 hours prior to move-in, is going through how to operate a smoke detector and the requirement of testing with a resident, and that is outlined in one of these two documents, I believe.
And how is that verified that that was actually done? Like, is there a form that's filled out, or how is that verified by Invitation Homes Realty and or THR Property Management?
So during the orientation, we fill out a move-in, move-out form. It's a condition form. And as part of that, there is a section for smoke detectors. There is also a deficiency list that is created if there are items that might need to be addressed that were discovered during the orientation process. And so what you have here on page 10 is a checklist of what an associate is to demonstrate, or the actions that they take as part of that resident orientation, and it's got a room-to-room breakdown as you go on. But the documentation of anything that is discovered would either be documented on that move-in, move-out form, or with a deficiency list, which would subsequently get a work order to be addressed.
Now, if they, is there a portion where you can mark that, everything tested well, or there are no issues, or how would you know?
Typically, if there are issues, the issues are documented and noted in the form and on the deficiency list. And then there are work orders created for any deficiencies.
How are you doing?
Good.
We've been going an hour.
Yeah.
I just
We
wanna
can take
make
a
sure
5,
you're
why don't we
good.
take a
No,
little
no,
break?
I'm good if you're good.
Yeah.
Let's go, we can take a 5-minute break.
Okay.
I gotta find the next exhibit.
Going off the record, the time is 11:15 a.m.